President Trump made a move last week that no president has tried in decades, federalizing a state's National Guard without the governor's approval. Is this a bold defense of law and order, or a dangerous overreach? Let's break down what's really happening. Welcome back to the channel, everyone. Today, we're diving into the legal showdown between Gavin Newsom and Donald Trump over Trump's decision to federalize the National Guard to shut down protests and riots in Los Angeles. A quick bit of background, even though I'm sure you already know what's going on. On June 6th, ICE conducted raids in Los Angeles, resulting in the arrest of 44 people on immigration charges. Protests erupted, some turned violent. Federal officers were hit with concrete, Molotov cocktails, rocks. In response, federal agents used tear gas and flashbang grenades to disperse the crowds. And there are also reports, although they are disputed, that the LAPD took multiple hours to respond to the federal officers' calls for help. The main flashpoint now is Trump's decision to deploy 2,000 California National Guard troops to support the federal agents and restore order. Gavin Newsom, the governor of California, has criticized Trump for escalating the situation and has filed a lawsuit alleging that Trump's federalization of the National Guard was unconstitutional. So, the National Guard is unique because it is under dual control. Both the state governor and the president have authority over the state's National Guards. Typically, the Guard is under the governor's control, but under certain circumstances, the president can federalize the Guard, putting the troops under what is called Title X status. So, when can the president put a state's National Guard under Title X status? There are a few statutes that allow this, and I'll put them on the screen as we go through them. Pay attention. I'll quiz you afterwards. Just kidding. But if you do remember them, you may finally impress your friends at Pub Quiz Trivia Night. So the first statute comes from Title X in the United States Code, Section 12406. This allows the president to federalize the Guard if there is an invasion, a rebellion against federal authority, or when regular forces can't enforce the law. The statute says that the president must go through the governor. The other two statutes come from the Insurrection Act. The first, 10 United States Code 252, lets the president federalize the militia of any state, meaning the National Guard, when he considers there to be an ongoing obstruction, assembly, or rebellion against the United States authority that can't be quelled by ordinary judicial proceedings. The second statute, Section 253, allows the president to federalize the Guard if he believes there's an insurrection that opposes or obstructs the execution of federal law. If the president uses the Insurrection Act to federalize the Guard, he must issue a proclamation ordering protesters and rioters to disperse within a specific time frame. This proclamation isn't just a tweet or a press release or a Truth Social post. So no Trump's Truth Social post saying the federal government will step in and solve the problem, riots and looters. That's not a proclamation under law. It must meet specific statutory requirements, including being typewritten, citing the authority under which it is issued, and having a dated witness signature. So did Trump have the right to federalize the National Guard in this instance? Legally, I believe, yes, he did. Some argue that there have been bigger riots in the past that did not lead to federalization, but I think the statutes are pretty clear. When there's a rebellion or obstruction against federal authority or federal officers, the president has the right to act. Whether he should is a totally different debate. But legally speaking, the authority was there. Rioters were attacking federal officers and obstructing enforcement of immigration law, which is a core federal responsibility. When the agents and the LAPD were unable to quell the riots, Trump was empowered to act. But here's where things get complicated because nothing with Trump is ever simple. While Trump did have the authority, he didn't follow the established procedures that make such a move legally airtight. Remember the statutes we went over? One says he must go through the governor, the others require a proclamation. Trump didn't do either of those things. Instead, Trump issued a memorandum citing his authority as 10 U.S.C. 12406, the one that requires him to go through the governor. This doesn't necessarily mean that the governor must approve the federalization of the troops, but it does probably mean that the president must at least attempt to work with the governor before federalizing the troops by himself. Historically, presidents have federalized the Guard by issuing a proclamation under the Insurrection Act and citing both 12406 and the Insurrection Act as their authority. Trump's use of 12406 alone is unprecedented for domestic unrest. The last time a president federalized the state's Guard without the governor's approval was in 1965 when LBJ sent the Alabama Guard to protect civil rights marches. Johnson, at this time, he followed the law to the letter. He spoke to the governor, was refused by the governor, and then issued a formal proclamation under the Insurrection Act. Governor Newsom's lawsuit claims that Trump's order violated the through the governor requirement of 12406, the 10th Amendment, and state sovereignty. He argues that the situation did not meet the criteria for federalization and that Trump's failure to follow proper procedure makes the order unlawful. As we discussed, Trump's on solid ground in terms of authority, so I think the 10th Amendment claim and the state sovereignty argument from Newsom are going to fail. That said, it is a California court, and they're hearing it today. Hopefully this video comes out before they issue a ruling on it. Either way, though, I think what I'm saying still will hold up. But we don't know what a California court's going to do, but they should say that Trump had the authority to federalize the Guard. Federal officers were under attack. Law enforcement was obstructed. I think under any of the 3 statutes, Trump had the right to federalize the Guard. But the procedural shortcuts create legal problems for Trump. By not following the steps, issuing a proclamation or talking to Gavin Newsom, Trump's giving California a credible legal argument, even though the underlying authority was sound. And this isn't the first time that the Trump administration has gotten into legal trouble because of procedural missteps. Take the Kilmar-Abrego case, for example. The administration deported a man to El Salvador despite a judge's explicit order prohibiting his removal. When the courts demanded his return, the administration dragged its feet, taking months to bring him back. Eventually they complied, but only after being repeatedly rebuked for violating due process and court orders. Then there are the tariffs. Trump invoked emergency economic powers to bypass Congress and impose sweeping tariffs on imports from literally pretty much every single country, including the lemur from Madagascar. The emergency that Trump declared were trade imbalances. That's hardly an emergency. Federal courts ruled that he overstepped. They blocked some of the tariffs, and above all, they sent a message to Trump saying that his power is not unlimited and process matters. This pattern runs through the Trump administration's legal battles. The authority is often there, but the failure to follow established legal procedures leads to defeat in court. Whether it's immigration, trade, domestic security, bypassing process, even when the law is on his side, has turned potential victories into costly setbacks. So today, we're left with a president who had the power to act, a crisis in Los Angeles, a president unwilling to do the little things right, and a governor positioning himself for a presidential run in 2028, and an ongoing legal battle that will continue past today. Once again, we see an administration that's willing to make the bold moves that are necessary, but time and time again, it's not the lack of authority that's creating the problems, it's the decision to cut procedural corners. And that's the real takeaway from Los Angeles, Abrego Garcia, the tariffs. In America, it's not just about having power, it's about using that power in a way that stands up in court and lasts beyond the moment. The rules and procedures are not just red tape, they're what make presidential action stick. Otherwise, it's like assembling IKEA furniture. You don't have to follow instructions, but you'll be left with 2 extra screws and a wobbly chair. Good luck. So as this legal battle unfolds, just remember, it's the strongest leaders that use every ounce of authority they have and make sure that every I is dotted and every T is crossed. That's how decisions stand the test of time, by being both bold and by the book. If you guys like this video, hit like and subscribe for more. I want to encourage discussion in the comments, whether you agree or disagree. I believe that it's only through discussion can we all come to a better understanding of the truth. And that's really what my goal is with this channel, to bring myself and others to a better understanding of the truth. And we won't get there if it's just me talking to my cat.